Advocates for Justice Paralegal School. We provide the tools, you do the work. Hey guys, I'm Coach Neighbors, and tonight's video, we're going to review the update to my sister's judicial foreclosure. I've been using her case to figure out what strategies we need to be changing in our program. We're going to also discuss one thing new that we need to be doing is moving the attorney's foreclosure over to state court ASAP. And you should have a removal document in your package. We'll talk about how to change that later on to help you get this done. And we're going to review the new strategy that you should be using, getting the document removed. We'll talk a little bit about that. The coolest thing we're going to do in this video, I'm going to review the attorney's response to our notice of removal. So that's going to be fun. But before we get to all of the yummy hot stuff, you guys please take a minute to subscribe to my channel and make sure that you hit the like button to let YouTube know that I'm bringing value to the table, and click the bell so you get notifications when it's time to rock and roll. When you click that bell, you get notifications when I upload videos or when I start a live stream, or actually you'll get a notification when I post that we're going to do a stream the following day or whatever. So make sure you click that bell. And last but not least, leave a comment. Oh, wait, least but not last, make sure you share my videos on your social media so other people can see that they have options if they're facing this problem. So let's just get straight into it. The update on my sister's case. My sister had a judicial foreclosure that I've been helping her with. To cut to the chase, make a long story short, when the judge stepped in to help the attorneys a year and a few months later, we objected, and this is what you guys should be doing. Anytime a judge makes a ruling in your case, you should, unless it's something that's helping you, which I doubt. So let me continue. So anytime the judge makes a ruling in a case, you should automatically object. You should file for reconsideration. Usually I do both of those in one document. So you file your objection and demand for reconsideration, and then you file a lawsuit against the judge. That's how we do it. And when we did that, the judge terminated the case. And my sister is really nice, and so she dropped her lawsuit against my advice, but you know, I'm just a coach. And 9 months later, they came back for some more punches. And we're punching them in the face some more. And we're going to talk about what we're doing tonight, and I'm going to show you their response so you can see how well it's working. And this moving in the case, I think, is critical because they're so used to just ignoring everybody, ignoring all of your stuff. It's administrative courts, not from the Constitution, so they don't have to give you anything. They don't have to give you squat. We need to figure out how to take control and then have another judge take over. And that's the process that we're doing with moving the case. Now, if you follow through the process, the main reason you're moving the case is because you're suing a state court judge, and any other state court judge that would have conflict of interest. So that even outweighs their statute that they're saying you can only move a case after 30 days and you can't move it and all this stuff. But we don't use their statute because we already know that their statute does not have an enacting clause, does not have a body, does not have a title. So it's not from the Constitution. It's not a valid law. We don't have to. What we use is court rules, and we'll talk about that later. We moved their foreclosure, the attorney's foreclosure case, over to federal court. Today, we moved her. She filed a $20 million lawsuit in state court, and she's the plaintiff, so she filed it and paid. Going to move that now over to federal court to be connected with the case. And well, she did that today. Oh, one other thing. She also filed her motion for summary judgment in federal court because the attorneys have failed to answer to the lawsuit that she filed on September 20th, 2021. And to date, they have not responded. And I think what happened with them is that they're so out of control, they just decided the hell with it. We ain't got to respond to none of that crap because we got it wrapped up. We got our fake sale date. So we don't need to respond to nothing because whatever, I don't know. I know they didn't respond. So we moved it over to federal court, and we also filed a motion for summary judgment because they didn't respond. And we attached a copy of the ROA sheet, which is like I call it the docket sheet. We attach a copy of the docket sheet to verify that they had not responded to date. And so I don't know how they're going to get out of that. But what I do know is that once you get that removal signed, state court's done. They have no jurisdiction. They can't do anything. It's a wrap. That is the reason why you need to get that done so that you can get full control over the state court process. And then they're going to try and send it back. But if you do this right, the easiest thing to do is to stand on the issue of the conflict of interest. The other state court judges have conflict of interest once you sue the state court judge. So we just do that to make it simple. Now, if you need to move your case and you have not done my process, you can still move the case and challenge the court's jurisdiction. And you can just keep it simple. Okay, the statute that they're using to do this is not a valid law. So that makes the foreclosure unconstitutional if the statute that they're using is not in line with the Constitution. There you go. I'll send you a bill. Okay, let me screen share so that I can show you guys a copy of what the attorney filed. Okay, here we go. So this is what the attorneys filed in response to our notice of removal. It's not a motion. It's a notice. You're not asking them for anything. You're moving it into the story. So keep that in mind. When you're using a notice of removal, you're not asking the court for anything. And the way you do this, you take your notice of removal over, you head it for federal court on the top, on the court heading, and you take it over and you file it in federal court. And after it's filed in federal court, then I did a judicial notice to let the state court know that federal court has jurisdiction there, whatever. Judicial notice is simple. You just write judicial notice letting the court know administrative facts. Not that big a deal. The advantage is that the opposing attorneys don't get an opportunity to object to it because it's not a motion where you're asking the court for anything that opens the door for them to argue. Remember, we learn how to do things without the arguing to close the door on their BS. As you can see here, he filed his motion to remand, and he states this is a residential foreclosure lawsuit. Well, no, that's not true. It's not residential. It's private property. Okay, the residential crap came in after they commandeered your original deed and registered in the office. Once they registered the deed in their office, your property was reclassified in one of their commercial classifications, residential, commercial, or agricultural. And then the property tax started and all of that. Once your property is registered, it allows anybody to put a lien on your property. And the very first lien that was put against property, people don't realize this, but the very first lien that was put against your property was the mortgage lien. The very first illegal lien was the mortgage lien. And if you stop and think about it, the fact that the bank accepted your signature on the stinking mortgage lien proved that you owned it. Or some other people would have had to come and sign because the owners had to be present to sign. And the fact that the bank accepted your signature only proved that you signed. I just like to keep it simple. It wasn't residential. It was private property. They're illegally foreclosing on private property. Well, they're trying in this case. And we never answered the counterclaim. We never answered them. We responded with our challenge of jurisdiction, proving that my sister was a state citizen of the Republic State of Kansas. And then we counterclaimed. And then we sued the judge. And he left that out because that could be in here. Oh, wait, we sued the judge twice. He wasn't very forthcoming here, but the federal court will figure that out today when we moved the lawsuit, the $20 million lawsuit over there. He forgot to put that in here. He mentioned their summary judgment was against us. Yeah, that was a summary judgment, and it was overcome when the case was terminated. After we sued the judge terminated the case. Termination is a final judgment, and so the case cannot be opened again without someone filing leave of court and having some kind of way to open it that new evidence or something. So what they're doing right now is just using the judgment from the same judge that terminated the case that we sued and that we're suing now again. as the door to get in there, open the door and get their foot in. And so we just shut the door on their foot and move their crap over to federal court. And so you can see here, he's not, he goes on about the order of sale. They never provided us any information about their request for a sale. And the funny thing is, we already had forced the judge to terminate the case. The only reason that a homeowner would not show up, the only reason why a homeowner who had the case terminated would not show up would be because they weren't informed of the sale, of the request for the sale. So, and that's all fine and dandy because we already see what's going on here. So we moved it over to the other court. And when they see the lawsuit that we have filed against the judge, it's going to be interesting to see if they want to play or if they want to force these fools to take the deal. That's what happens in federal court. They ain't trying to have no damn trial. Everybody's got to take the deal. So he complains about here that this is an attempt to upset the sale date. You think? And untimely and improperly files her notice of removal. Untimely and improperly. Well, the federal court accepted it, so I think the improperly was incorrect, and you can do this at any time. Maybe it was untimely for them, but not for us. So yeah, so you can see that took some air out of his tires. So he's demanding the court must immediately remand this case and deny the defendants a right to any future removals to prevent the defendant from continually and unlawfully interfering with the sale date ordered by the state court. I wonder why he didn't discuss any of the reasons why we're moving the sale. He didn't discuss any of those. As a matter of fact, he didn't give any reasons why anybody should listen to him. Oh, wait, because it was improperly filed and untimely for him. Oh, so I don't know how this is going to work out, but from where I'm sitting, we're looking pretty good right now. Yeah, he's going to have a heart attack when he sees that we moved the other lawsuit that he didn't mention over. And not only did we move the lawsuit over, we also filed a motion for summary judgment because they failed to answer in 65 days. Yeah, I don't know if you guys can tell, but I'm having a little bit of fun over here. So I don't get to have this much fun very often, so I'm enjoying it. Now, there are a couple other things that we want to talk about today. Well, everybody who invested in a package has a notice of removal in your package. Now, what I need you to do this notice of removal, now, if you need to breathe in a paper bag, go get your bag, okay? Because this is not that complicated. What you need to do is you need to Google the court rules for moving a state case to federal court, okay? Don't pay any mind to their statutes they want you to follow, because the statute says you have to wait, you can't move it after 30 days, and you can't do this, you can't do that. Now, all that crap is BS, okay? I don't use the statute because the statutes are not real laws, and it's funny how it goes. The attorneys use the statutes to beat us up with, but when they can't beat us up with the statutes, then they'll try and use the rules. But when we try and use them, it's a problem. So that's all right, because we're using them anyway. Don't pay any mind to the statutes they want you to follow. Look up the rules, Google the rules for moving a state case to federal court for your state, and you'll see it's very simple. All you have to do is put your stuff in there, and I would copy and paste the address, that statute, in the front page of your document, so the clerk will know that you know what you're doing, or at least it looks like you have an idea that you might know what the hell you're doing. Yeah, and take it down and get it filed. And shortly after, I would have the restraining order put together. And remember, The main reason why you're moving this, if you've done my program, is because you're suing this state court judge. That just keeps it simple. That keeps it simple. Or you can be moving in for any of the reasons in the 7 pages of the jurisdiction challenge, the jurisdictional challenge, or the jurisdiction challenge / lawsuit with an affidavit. Any of those reasons. Or if you just want to move it because the statute is not a valid law because it doesn't have the acting clause, doesn't have the title, and doesn't have a body. It doesn't have the 3 things that your state constitution mandates must be present. So the whole foreclosure is it's unconstitutional. So you can use that or all of the above. Now, when you move this, you must add a copy of their original petition to your notice of removal, and a copy of the sale date, the sale date order, the sale date or whatever, or copies of the eviction process. The idea here is to provide the federal court with any documentation that you need to show that you're going to be injured if they don't grant the TRO, if they don't grant the restraining order. And keep in mind, the restraining order can be granted by the judge without the attorneys having any response to it. You just have to be convincing and make sure you put in there documentation to show that you need this restraining order to be granted ASAP. Now, we've been verbally harassing them butthead and letting them know that we're willing to settle under certain conditions. One of the conditions is that they deliver the property deed as mandated by state law. And the second condition is that they remove the property information from the state computer system, and that they pay legal fees in the amount the attorneys were going to charge the homeowner for their illegal process. And they really pissed my sister off now. So the $20 million is still on the table. So that's all I got to say about that. So the $20 million is still on the table. Now my sister has moved the attorney's state foreclosure case over to federal court using their own court rules. How you like it now? How you like me now? Who's your daddy? Okay, never mind. I'm gonna teach you guys how to toss some crap when you call them up on the phone. We moved their case over to federal court, and there ain't a damn thing they could do about it because it's done. And the attorneys failed to address any of the reasons why we moved the case. How funny is that? I mean, that it was untimely and improper. The attorney stuff that he filed to remand our case, we're going to file a motion tomorrow to strike everything that they filed because the attorney signed it himself. And that's not the way this is going to go. The attorney's going to have to start learning how to follow the rules now because we're in federal court. Attorney needs to hire a federal attorney because the attorney can't represent himself. He can't litigate a case that he's a party to, and he can't represent the law firm pro se. That's not allowed in any court or federal court. Now the attorney gonna have to spend some money or something. I don't know what he's gonna do. They can get my sister's deed out of their office and get it back to her. I don't know. If they don't want to do that, then we got crapola for the programmer. Oh, so I'm thinking maybe the feds can get him an attorney to help him make a deal with us. That's what the video is about tonight. The next, I'm going to do another video at the end of the week, and it's going to have another update about what's, about the attorney, how he responds to the motion for summary judgment. So thank you guys. Thank you guys for the privilege of sharing your time, and I will see you in the next video.